Can you hear me?
I can. Can you activate your camera?
Yes. Just give me a second.
Hi there. So are you, is it Muhammad Idris?
The trustee. I'm the trustee. The trustee of the person is here, and all the beneficiaries have been already named.
Okay, so I'm looking for Muhammad Idris. If you're not him, you're free to go. We'll issue a warrant for him.
I am the trustee of the person.
So, okay, I'm not sure what that means. You're going to have to explain that to me. I mean, I know what a trustee is. You know, when they have a trustee over as a person, that's someone who governs their affairs if they're not able to manage their own. Generally, people aren't trustees for themselves, and so that's why, you know. And if you're, I'm not sure exactly what that means, and you're gonna have to explain that to me.
What I mean,
like I say, if you're, I mean, I'm sorry.
What I'm saying is the trustee of the person is here, and all the beneficiaries have already been named, and it's on a trust, and that trust is private.
Okay, do you have a name?
Because you are claiming that you are the trustee, or the prosecutor is claiming to be the trustee, and the investors.
No, I'm not.
The beneficiaries.
Okay, I'm going to stop you there for a second because I'm not claiming that. No, you can't finish. When you say you are claiming to be something that I'm not doing, no, I'm not going to say that because that's not true. I'm not claiming to be anything other than the judge in Thurston County District Court who's on this calendar. So I'm not the trustee of anybody.
Well, you're here to come after my personal trust, correct?
No, no. Why would you think that?
I object being a trustor.
Okay, well, you're not one. I'm just trying to find out who you are.
I can't get any clearer when I said the trustee of the person is here.
Okay, is the person here? You're not going to answer that.
The trustee of the person is here.
Okay.
And the beneficiaries have already been named. Is on a trust, and it's private, and my trust is private.
Okay. What's the state's position on where this case is headed? And then I can come back and speak with
Your Honor,
who I assume the trustee of the person is the person named as Muhammad Idris. And so, but let me hear from you what the state's position, I mean, these cases look like there's a fraction of failure to control a traffic device. There's a special fuel trip permit. And then there's a failure to comply charge.
Yes.
So what's the state's position on where we're going from here?
If Muhammad Idris is not present, the state would ask for a warrant.
Muhammad Idris I'm going to consider him present based on his verbiage. I know he's operating under a lot of false premises, but that's kind of on him. So,
right.
But I mean, what is the state where we're at here? If the state wants to go to trial on this case, we'll set it for trial, and then
the state would ask the court to set dates.
Okay.
In speedy trial, the state also would like to clarify whether Muhammad Idris is intending to go pro se or if he will have counsel at trial.
He looks like he was okay. So I'm going to speak here for just a minute, and I'm going to kind of tell you where we are with this, and then we'll go from there. So, you know, you said a lot of things already that just simply are not correct. And here's where you're at right now. All right. And so you've been charged. There's 3 things at issue here. There's 2 statutes that are alleged to have been violated: violation of a special fuel trip permit, violation of vehicle operator refusing to comply with an officer. And those are both, I think, simple misdemeanors, which carry with them maximum penalties of 90 days in jail and a $1,000 fine. Pleas of not guilty have been entered. And then these cases, they're both criminal cases. And what happens is they either resolve through some sort of plea or some sort of agreement, or they proceed to a jury trial. And now, if you go to it, since they are criminal cases, it's headed to a jury trial, you're entitled to be represented by an attorney. Look like a previous judge had already ruled that, or found that you were going to, are you going to represent as the person, as the trustee of the person of Muhammad Idris, going to be present to contest the criminal charges against the named Muhammad Idris? Are you going to do that yourself, or do you want to have an attorney appointed to represent? I can screen you for court appointed counsel, or you can hire an attorney to represent yourself.
Do I have a standing to speak?
Yes.
Okay, I object to what the prosecutor has said.
Okay.
And I'm standing on, I am. Like
you're standing on what?
The trustee of the person is here, and the beneficiaries have already been named.
Okay.
It's on a trust and it's private.
Okay.
And I object to the prosecutor saying that representing myself, I object to that. I object to being the trustor. And I'm not here to give out gifts, reducing the public law or the public debt. Because I'm brought in as a trustor to give out gifts, and turn around, and what the court is doing is coming after me for the commercial promise. So for that reason, I am the trustee. I'm standing on that position.
All right.
And I'm not here to give out any gifts.
Okay. No one's here for any gifts.
So I object to that. The trustee of the person is here, and all the beneficiaries are already been named.
All right.
And I'm not talking about the beneficiaries, which is the investors.
I have no idea what you're talking about. When you talk about the beneficiaries, I don't have a clue as to what you're talking about. So I don't even know what that means. I'm trying to figure out, where we're going to go from here. And I have an idea, but in a minute, I'm going to take up some of these. I'm going to take some of these other cases, and then I'll come back to you. But
I'm the only witness on the case, correct?
No, you're not. That's not correct. No. Give me just a second here. Mr. Newcomb, you can mute up there, Mr. Idris, and then I'll come back to you here in just a minute. And you can go off camera, but don't leave the Zoom call just yet, because this is going to take some time. I'm going to take care of some of these other cases first. Mr. Newcomb, is your case ready? I don't hear him. And then Ms. Lazarek.
Your Honor, we'll be doing a change of plea today, but I'm just waiting for my client to log on.
All right. All right. So you can come back on the, you can come off the Zoom call there. Mr. Idris, you can come back off of mute. You can come back onto the Zoom call. So here's where we're at here. And I started talking about, and again, at this time, I don't want to hear anything about the trustee and the named or unnamed beneficiaries. My only question is, do you want to have an attorney appointed to be involved and help you with this case? I mean, that's a yes or no question.
The trustee of the person is here, and the beneficiaries have been already named. And I'm asking for the court to dismiss this case because I put myself in the position of a trustee.
Okay. The request to dismiss the case will be denied. I'm telling you that. And I'm going to ask my question again. Do you want an attorney appointed to represent you, or are you going to go it alone?
How can somebody represent me when I'm the trustee?
Okay.
And the beneficiaries have already been named? You can't even continue.
Why do you think that?
What does it have to do with thinking?
Yeah, that's a good question. Well, I mean, you're just telling me that, well, I've named the trustee and the beneficiaries are named who haven't been named to me. So I don't know who they are, and they're really not interested. I mean, if life were that easy, anybody could do that in any criminal charge. Anybody get charged with anything? Well, I'll just name myself the trustee of the person and name some beneficiaries, then you're off the hook. You know, things just don't work that way.
How come they don't do it?
And so in terms of, you know, at some point on the, there was a scene where you were contacted by a law enforcement officer, or maybe even more than one. They identified some charges or some statutes you were not complying with, including, you know, the special field trip permit, and you refused to comply with the officers and things of that sort. So they refer that to the prosecutor's office. They're charging a crime. And I've told you what those two crimes are. And now, again, these cases either resolve, and if you've been on the Zoom call, which I think you have for a while, you've seen some of these cases resolve, or they go for a jury trial. And again, you've seen all these other attorneys who represent these folks. I mean, if they could make these cases go away simply by naming someone as a trustee or naming the charged person as a trustee, I mean, shoot, they'd all do it. And then nobody could ever be prosecuted for anything. So that's why I'm wondering why you think that. And now I'm losing my voice, but it'll come back, I promise. So if you're going to keep just
go ahead.
I mean, if you're just going to keep repeating that to me, then not much of a choice other than we'll just set this to a jury trial, and then you can repeat that to the jury and see how that turns out. But I don't really have much of a choice here right now.
I object. Isn't the prosecutor supposed to be speaking and ruling between me and the prosecutor?
Say that again. I didn't understand that. Would you please repeat that?
How come the prosecutor is not saying anything? Why is the prosecutor silent?
Well, because part of my job is trying to identify who's here. And then the prosecutor did say that they want to figure out whether you're either representing yourself or you want an attorney. And so that started the conversation between me and you as to whether or not you want an attorney or not. And I frankly, I still haven't gotten an answer. When I ask you that question, you just go back to restating yourself as the trustee of the person of Mohammed Idris, and then the beneficiaries have been named. So I want to get through that hurdle. And then, I have some responsibility to do some things here before we really hear from the prosecutor. Prosecutor will, I suppose, if this case goes to jury trial, they'll do that. They can negotiate with you some sort of resolution to the problem if you wish to do that. I can set this over for a period of time to give you an opportunity to do that. But and again, you still haven't even admitted that you're the person who was pulled over by the police officers on that day. So, I mean, we kind of have to get through some of these preliminary hurdles before we can get to that.
The trustee of the person is here, and the
I know.
beneficiaries have
You
already
have
been
said.
named.
You have
The
said. You have said.
beneficiaries have already been named.
All right. Do you understand that the prosecutor is an attorney who's passed the bar, practiced law in the state of Washington, appears here fairly regularly, and knows the rules of evidence and criminal procedure, and quite familiar with them, given that that's what their job is?
I object to being the trustor.
Okay. Do you understand what a prosecutor's job is?
I object to being the trustor.
All right, you can go ahead and mute back up. You can stop your camera, and then all right, Mr. Idris, you can come back on the Zoom call, please. Activate your camera. So I'm just going to talk for a few minutes, and then I'm going to tell you what we're going to do here, going from here. It looks to me like your first appearance on these cases was on July 17th, and speedy trial runs through right now, October 15th, 2023. So you are charged, as it looks like you were in front of a pro tem back on July 17th. You're charged, right there, with 2 crimes, and there's 1 infraction. Pleas of not guilty will be entered. Anytime anyone's ever charged with a crime, they have a number of rights. You have the right to be represented by an attorney, which I've talked about. You also have the right to go to trial and call witnesses and so forth. And so just let me finish, please. Don't interrupt me. I know what you're about to say, but I'm going to talk for a while here. So just please don't interrupt me. At the end of it, then you can say what you're going to say. All right.
My apologies.
So this case has started. This case is headed towards trial, apparently. And if my voice holds out, the trial is going to take place someday before October 15th. You have the right to an attorney, as I said. You also have the right to represent yourself. If you choose to represent yourself, I just want to advise you that you would be at a serious disadvantage. The prosecutor, as I tried to explain earlier, is a trained attorney, been through law school, been practicing law for a while, well-trained, well-versed in the rules of evidence, well-trained, well-versed in the rules of criminal procedure, been through jury trials before, they know how to conduct them. And so if you were to represent yourself, you would be at a huge disadvantage. It would be to your great advantage to have an attorney appointed, or you can hire an attorney to represent you. But as I said before, you do have the right to represent yourself. And normally you go through some sort of conversation with folks. I've been doing this job for a number of years now. I've had several people represent themselves. Normally there's a conversation I've had with people about asking them that they're aware that if they represent themselves, they'd be at a disadvantage. I tried to engage in that discussion with you. You just kind of reverted back to repeating that you're the trustee of the person and the beneficiaries and the name, so forth. But rather than go through the question and answer portion, I'm just going to tell you that's where we're at. So we're going to set this case. We're going to do 2 things here today. We're going to set the case for trial. You're going to get notice in the mail of that. You're also going to I'm going to set a status hearing or a pretrial hearing in about 3 weeks. And then somebody else, maybe it'll be me, will probably try and go through all this again. But I'm going to tell you some things that, you said you object to this and you object to that, and you're free to object to anything you want. But I have the ability to either overrule the objection, which means, turn down your objection, or sustain your objection. And I'm having trouble actually understanding what your objections are. And so, and again, I'm going to lay out some of what's going to happen at trial if it goes that far. In a trial, they have a group of citizens come in, both the attorney and defense attorney, or the person represent themselves, and the prosecutor has an opportunity to question them, talk about the issues that might come up in the case. Then they can eliminate who they don't want on the jury, and then 6, you will end up on a jury, and then the state will present their case. You or an attorney, or you on your own behalf, or you as the trustee of the person, can present your case or explain to the jury why you think you should be found not guilty of what you're charged with. And so in the grand scheme of things, frankly, the charges that you're charged with are not far from the most serious that we see around here. They're not. But they are crimes, and they are in their own way serious. And so I don't know whether anything I've said has made any impression on you at all, but that's what's going to happen here today. And if you wish to, so this case is headed for trial, and like I say, we'll do sometime before October 15th, but we're going to do a intervening, and I'll tell you when that is. Why don't you set just a status pretrial for like about 3 weeks. And you can think about what's going on here. You can think if you want to take some alternative place. If you want to just come to court and keep repeating the same thing to me when you get in front of a jury, you keep repeating that same thing to somebody else, I suppose there's no way I can stop you of doing that. But I'm just trying to enlighten you on what's going to happen. And, some of, your objections you talk about, see, that's the advantage the attorneys have. The attorneys know when objections are well-founded and when they're not. And I kind of get the sense from you that you really don't have a complete or accurate idea of what this is all about and what's happening. And so I tried to spend some time explaining that to you as best I could. And I guess I told you I'd let you speak, or hinted that I would let you speak. I'll go ahead and tell you. Do you have any response or any thoughts on this, or would you understand this is going to trial? Or go ahead. I've said what I'm going to say. I'll turn things over to you. Any response to any of that?
Again, I object. I'm standing at what I said.
Okay. And what specifically do you object to? Just so I can create a record, so I'll make a ruling on your objection. What are you objecting to?
I'm objecting to everything you're saying. It's a hearsay. It's an assumption, a presumption. It's a tacit agreement. It has nothing to do with the facts. That's why I'm the trustee. It has it has everything to do with the trust law. The trustee of the person is here, and the beneficiaries have already been named. That's why I have a trust, and my trust is private, and I don't see your trust. And in the trust that you have, the trust that the prosecutor has named you as the trustee. That's why you keep asking the prosecutor what they want to do, because they named you the trustee. And you guys brought me into court to bear gift, to give out gifts. And I'm not here to give out any gifts.
Right.
I'm here to object to giving out any gifts. That's supposed to reduce the public debt. Am I wrong?
Yes. Yes, you are. And that's frankly, that's kind of the sad thing, because I'm really not sure completely of what you're saying, but a lot of the things you just said are quite simply not true. And I asked the prosecutor where they wanted to go in the case, because they file the cases, they choose to go forward. Sometimes, as you've seen today, if you've been paying attention, the prosecutor said, "No, Your Honor, we're going to dismiss this thing." And so I dismiss it. So I asked the prosecutor, they filed the case. What do you want to do with this case? They said they want to go forward. which brought about this conversation that we've been having. And that's just one example of one of the things you're wrong about in terms of this whole trustee thing. I don't know what that means to you, but I have an idea of what a trustee and is and things of that sort. And I don't have a trust. I'm not anybody's trustor or trustee. In this court, neither is the prosecutor. And so when you say, am I wrong? You know, the short answer to that is yeah. And unfortunately, and I'm taking some time to try and explain it to you, but I just don't feel like I'm breaking through. But to answer your question, am I wrong? Yes, you're wrong about a number of things, which is really unfortunate that I can't explain that to you or make that clear to you.
What's your evidence? Evidence is clarity.
I'm sorry?
What's your evidence that I'm wrong?
Well, I mean, you know, other than me just telling you that I'm not a trustee, I can't prove something doesn't exist. I mean, there is no trust. There's nothing else, and I have no documents that saying there's not one, and I don't have any document. There is no document saying that there is one. And so again, that's on that single issue. That's
so you're not coming after my personal trust?
No.
So personal
and again,
trust
I'm not
doesn't
sure.
exist?
Well, let me rephrase. I'm not sure what that means. Again, you're charged with a crime. That crime needs to be resolved or either through trial or resolution of some kind. And so in terms of coming after your personal trust, and by the way, you know, I'm not the one who filed the charges. That was done by the prosecutor and all of that. And so what they're trying to do, I think, and I don't know this for sure, and I'm just trying to do this by way of explanation, not because I'm on anyone's side. You know, it's their responsibility. They're bringing the charge. It's their responsibility to prove it beyond a reasonable doubt. It's your or the defense attorney's role to say, explain why the charge should never have been brought, or that there reasonable doubt exists as the charge was ever committed. That's what this is about. This whole trust thing, I think you're just going down a way that's really doesn't have any relevance to what's happening here. And I've tried to explain that to you, and I'm more than willing to continue. We can't go at it all afternoon, but I'm trying to make this as clear as I can to you. But and again, it's unfortunate. It's a failing on my part that I'm not able to break through to you.
Your Honor, if I might for a moment.
In a minute. So I guess we'll set it for status hearing. We'll set trial dates, and then we'll just go from there.
Your Honor, based on this conversation, the state has concerns about the defendant's competency.
Yeah, we're not going to go down that route right now. And so you can raise that, but I'm not denying that without prejudice. But at this time, we're not. For one thing, as you well know, given the nature of the charges and given the schedule, this case will drag everything on we'll be here for the next couple of years. And at this point, I'm not prepared to do that. So you can bring this up again if you wish, but for right now, we're not going to go there. And do you understand what the state just said to me and what I turned them down for? Again, that's a yes or no question. The representative from the state, the prosecutor, she just said something to me. And I said, no, we're not doing that now. She made a request of me. And so do you know what that request was?
I am the trustee, and the beneficiaries have been already named. So,
all right. Did she been sent discovery?
No, Your Honor.
Okay.
Because
Yeah, I understand why. I understand why. All right, so what's 3 weeks? What's 3 weeks from today? When's the trial date?
September 13th.
We're going to reset this to September 13th. Put it at the end of the calendar. Or
Okay.
what time?
2:30.
At 2:30. That'll be your next court date.
226707 ST and 162435 FY. Concerning the matters then we were set over from last time. Mr. Downing, in regard to the underlying matters that are left open, has there been any progress?
Your Honor, an offer, I believe, was extended to Mr. Martinez by letter dated June 8th, while he's been incarcerated in the jail. We have not heard what his response is, so I will leave it to Mr. Martinez whether he wishes to enter a plea pursuant to that on the 2 files he has to that offer, or seek an adjournment.
All right, we're also here for sentencing on a number of contempt. So in regard to the 2 open charges, Mr. Martinez, and you're proceeding here today in general, are you choosing to proceed without a lawyer here today?
Yes, I am, Your Honor.
So concerning the 2 files that remain open, 6707 and 7407, Ms. Cass apparently sent you another offer after we had court last time. Mr. Martinez, I have no idea what that offer is. The court is not part of any plea bargaining. You have both of these cases here. What is your position in respect to whatever they sent you?
I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And also, I didn't get, last time we were in court, I expressed to the court that I wasn't able to have reasonable time or an adequate law books. They're old. I only got an hour and a half. I only know some rules for an hour and a half of studying. So out of my freedom of speech and the rules of professional conduct, I'd like to read my motions.
All right, go right ahead.
For every waste of time and the more money of the people and their state, I would like to say this under the right of free speech, and I would like to invoke on my rights, civil and state laws, to state and file motions and to be treated fairly by judge and prosecution, to uphold all the laws that are to be held in the courts, and so as me representing myself can have a fair chance without having rights infringed upon by any members of the court, and I'm doing so. I'd like to file a motion to have all charges dismissed upon my rights being infringed and violated. Due to these reasons, rights to speedy trial and to have adequate time to with representing myself, and in doing so, these are my civil rights and need to be enforced and protected. Not enough time to study even after motion, or the judge throughout plea not able to study in a reasonable time, having defended myself when it was brought to the court's attention and prosecution. If need to, it's all on court record, transcripts and rights of trial by jury, and adequate time to have my own witnesses, which are under the time frame, and the prosecution knowingly didn't explain what or help me, which is repugnant and biased by the court, and for also the court saying and giving false advice, and also for my bond being excessive and also biased in setting bond by stating it's more than fair when I was unable to bond out, and when it was amended, I have reasons why 30 days from the time line of being able to represent myself is being infringed on, and I'd like to have my trial by jurors And these are the few offhand as to why most of the Speedy Trial Act and also False Pretense Act 774.49, they have to abide by all Supreme Court rules and also rules of professional conduct. Opinion 4, which is federal, asking for help retaining for motion, prosecutors rule 3.8, didn't take action or all actions, making sure my rights were protected, and rules 4.3, if they know the law and what I'm saying, these are US Supreme Court, Michigan rules, and impartial trial, miscarriage, also People versus Lehman, stating that I shouldn't be in jail or in prison for fines when able to prove I was unable to meet the court's obligations. And I was also in jail during the time of the one failure to appear. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half, when I've asked every day to go to the law library and kited, and there's no way that my act to speedy trial, if you need that read, can ever be met. And I got a bunch of federal laws too that if we have to go through all them, why? Or I can write them up in a motion to have more reasons for dismissal.
All right, thank you, Mr. Martinez. Mr. Downing, do you wish an opportunity to respond, or do you want an opportunity to do a written response, or where are you at with that?
That's a very rambling, if you want to call it, motion. I don't know how any kind of speedy trial is impacted here, in as much as one of these was just set for trial and the first trial date was today. He also failed to appear on the other one. He's set for sentencing on that. If he's complaining about legal research, he has a right to a court-appointed attorney to assist him in advising him of all that. I do know the record 2 handwritten responses from Mr. Martinez in response to Ms. Cass's offer letter asking to discuss the offer with her. It says nothing in there about speedy trial or anything of that nature. To the extent that he's setting himself up or trying to set himself up for these objections, I don't think there's any basis for it whatsoever. But if the court would like a written response, we would need a transcript of what he has rambled on about here in order to decide what it is exactly he's arguing.
All right, in regard to the matter, we've spent a good hour and a half or more on the record. I think it was last week, maybe the week before. We went through a whole plea colloquy. We got down to the end, the deal had been made. He decided at the last minute then he wanted to have a trial. So we set this matter over to today's date. He didn't want a lawyer then. He doesn't want a lawyer now, yet you want to complain that you don't have access. You're going up against people with 8 years of education. Which is it, Mr. Martinez? You want to represent yourself or you want a lawyer?
I want to represent myself, but I also was given false information by some court officers that I wasn't allowed to have a standby counsel or have advice by a counsel. And I know there's also a federal law that says that I'm able to have third-party advice. So I like I said, I only got out for 2 days, really, the last 2 days. I don't know how I'm supposed to be able to study upon the law, which I stated last time that the law books are and pages are missing out of them. And I showed guards that last night. Like there's no way that will have 30 days to be able to study and defend myself from the time of this trial. And it states that there's a federal law that, and if you want to see the Speedy Trial Act, I have it right here. I can read it off.
Pretty familiar with that. I've been at it about 35 years now.
Okay.
So in regard to the matter, Mr. Martinez, your motions are denied. In regard to your lack of a speedy trial issue, the following is my finding. One, first off, I'm going to sentence you on all of these failures to appear in contempt of courts. Last week, you had the opportunity I dismissed and purged 2 of them. If you pled on 2 of them, we got through the whole plea colloquy on that, and oh, you didn't want that either. So then we went through the hearings, and I found you guilty of 4 contempts because you failed to appear 3 times and you haven't paid. We're looking at a what, 2016 case that you still haven't paid on. So this is my sentence. You want to say anything in respect to your failures to appear sentencing before I impose sentence? Mr. Martinez.
Yes, there's federal laws state and that you cannot imprison somebody for fines being unpaid. And I already told you that I can prove that I wasn't there. You guys know the law. You're supposed to uphold it on both sides. I know that.
Well, I made my findings. You are able to appeal anything
you gave me
you wish.
bogus
Mr.
information.
Martinez.
You're not supposed to give me legal information. That's not you're not supposed to do that. The only thing you can tell me is I can go by representation or I'm allowed to have an attorney. You gave me bogus laws to look up and information and you were biased. So there's another reason.
Well, Mr. Martinez, your objections are noted for the record and preserved. In regard to the matter on the failure to appear and failure to pay in 162435 FY, I'm imposing 45 days in jail, 23 days of credit on both counts. In respect to 226707 ST, 2 failures to appear, 45 days in jail, credit for 23 days concurrently with the other case. However, at this point in time, Mr. Martinez is 1, serving a sentence, 2, has failed to appear numerous times in this trial previously, including several trial dates that were set timely. And the reason that it's not going to trial, for example, I gave him a timely trial date back on April 29th of 22, when he didn't do us the courtesy of bothering to come to court. So I am finding under the court rules, there is good cause and clear and convincing evidence that's been demonstrated that he's likely to fail to appear for future proceedings, should I give him a PR bond on this case. So for those reasons, I'm leaving the bond in place. We'll set a firm trial date for July 10th. We'll trail the new file along. And if you change your mind about a lawyer in the meantime, Mr. Martinez, you can make the request to the district court clerk. She'll refer it to the Michigan Indigent Defense Commission. They'll decide whether you qualify. In the meantime, the sheriff has the purview of the resources over there. You're entitled to use the jail resources. The sheriff is the one that's going to decide what the time parameters are. I don't have any control over the sheriff. So you can complain. Your record is set. You have made your record. It's all preserved here today. But in respect to the issue, if you really want to have some assistance and get some meaningful legal advice, I would suggest you apply for a lawyer instead of just complaining about it. But that might actually get you somewhere. So I don't know, Mr. Martinez, it's on you.
Ms. Renfro, you can come on. All right, I have 3 files here. I have, looks like 2 civil infractions, 1 misdemeanor case. Misdemeanor file is 25F00373ON. People of the City of Burton versus Christopher Allen Renfro, and then the 2 civil infractions, 25F00141OI and 25F00394OI. People of the City of Burton versus Christopher Allen Renfro. And Attorney Odette.
Good afternoon, Your Honor. This is the time set for a pretrial and possible motion hearing. I received no motions. I don't anticipate there being any at this time. And we're just asking if we continue to the jury trial date, as my associate has indicated that Mr. Renfro is not inclined to accept any sort of offer.
All right, thank you for that. And then Mr. Renfro, can you go ahead and state your name for the record?
My name is Christopher Allen Renfro. Today I am demanding a vacate of these matters, for I still do not consent. The jury trial is not a grand jury, so it would be a violation of the provisions of the Constitution of the United States of America. Also, the traffic tickets were not criminal, which this jurisdiction is for criminals, so I'd like those vacated also. no, there was no proof nor burden that the testimony of the cop was proved to be true. And also, no evidence. I still have not gotten discovery, which means it doesn't sound like the plaintiff is ready to move forward either. So that's my statement. I demand the court to vacate these matters and restore a new hold again.
All right, thank you. So most of what you stated is incorrect, and I'm denying your request to vacate or dismiss. The proper term would be dismiss, but denying that request. One thing that you did mention though that I do want to talk about is the discovery issue. And so is there any discovery that Mr. Renfro made that he does not have?
There's a police report in the criminal matter and then the tickets that he received.
Has that been provided?
I have no way to provide that to Mr. Renfro. He offered it to them previously and we do not have to take that.
How would you like that to be given to you, sir?
Well, the 24th was the cutoff, so we're past the cutoff. And that means that there's no discovery on either side.
What it means is that the rules in this court are set by me, and if you want discovery, we don't interrupt each other. If you want discovery, because you just stated you wanted discovery, so if you want discovery, I'm gonna make sure it happens. So if you want discovery, how do you wanna give it to me?
I don't. We're past the cutoff line and I want to vacate.
He doesn't want it. All right, well, if you don't want discovery, that's fine. In regards to work also, I want to mention, not right, but somewhat maybe along the path towards that somewhere, when you stated the thing about the civil infractions. So you're right, civil infractions are not criminal matters. They are civil infractions for a reason because they don't carry any penalty of going to jail or anything like that. And so you aren't entitled to a jury trial on the civil infractions. You are entitled to a formal hearing. So my plan would be to have the formal hearings either before or after, depending on how it works out, the jury trial on the misdemeanor matter. Attorney Odette, do you have any objection to that?
I have none, Your Honor, thank you.
All right, and Mr. Renfro, I know you don't want to be here, you don't want to do any of this, you don't consent to anything, but nobody here on a criminal case really consents to it. So is that all right if we do those things at the same time, or would you prefer to come back on different days?
Consent comes from the Declaration of Independence. Their second paragraph down talks about the consent to be governed, and also William Lynch letters talks about when slavery ended, commerce was created. What differentiated the two was consent. So maybe we need to go back to our books.
That is a very interesting concept. If, again, incorrect. Also, Declaration of Independence isn't law. Declaration of Independence was a declaration that we made to the King of England about what we wanted to see happen in this country. So that's not law, I wouldn't quote that anymore. I would quote
reasons why
other
we went to
things.
war with England.
One more
was
time,
Sam in America.
we don't interrupt each other. We're gonna keep doing this, and I'm gonna keep reminding you of that, because if you try to do it while we're having a jury trial, I'm gonna shut it down way faster, because we're not gonna do it in front of a jury. All right, so again, remember, we don't interrupt each other. So let's go back to the question, which was, would you like to do the jury trial and the formals on the civil infractions on the same day, or would you like to do them on different days? That's the only answer I need right now.
Proceed how you feel, because you already have, so.
Okay, I agree with that. So we will set them for the same day. I think that will be more convenient for everyone involved.
Thank you, Your Honor.
We do try to be convenient for people around here. Okay, and so let's set this then for.
I believe it's already set. I believe there's already notice for the, I don't believe it was on 8/7 yet.
But it was not set for today.
Okay. If we set this for August 7th, Mr. Renfro, is that an acceptable, and I know no date is acceptable to you, but are you free on August 7th?
On summons, I'll be here.
Okay, all right, you'll get a notice. We won't send you a summons, but we will send you a notice for you to
Only
be here.
summons a civil debt.
Well, if you don't show up, I'm gonna issue a bench warrant for your arrest, so be fair warned. August 7th, jury trial, 2025, August 7th. at 8:30 a.m. That will also be the same date for the formal hearings on the civil infractions. And like I said, I'm not real sure which ones we'll do first or last, but I'm thinking we'll probably do the jury trial first so we can get the jury in and out of here, and then we'll move on to the civil infractions. That way, if we have to come back the next day on the civil infractions, we don't have to bring the jury back. Last thing before we leave, Attorney Odette, you mentioned that, actually, there's two more things I want to talk about before we leave. One, you mentioned that today was set for pretrial and motion, and I do have as well have it, there was no stuff for motions, but I don't have any written motions filed. Did either of you file any written motions?
I did not, Your Honor.
Did you? Mr. Renfro?
No, I do not.
No? Okay, all right, so I don't know why that was set for that. I know you made an oral motion today, but, all right. Well, then that's not an issue. I will also note that right now, the jury trial actually has a date for Friday, September 5th at 9 o'clock.
Yes, that was the date that we subpoenaed.
This is the date of Mr. Becker's trial.
Okay,
And we originally scheduled it to coincide,
gotcha,
and it just kept moving forward.
gotcha. All right, so we want to do August 7th or September 5th, it's like either day is gonna be fine.
All in the court's discretion.
I'd say August 7th is good a date as any, so we're gonna, we had it originally set for, I think it was, July 25th, we had to move it because there was some kind of emergency or something. I don't remember what happened on that date, but it was something weird. So then we moved it, but we'll move it back to August 7th, that way we can get Mr. Renfro in a little bit sooner rather than later. I think those are all the things that I wanted to cover, except one more time, Mr. Renfro, I know we've already talked about this, but it is your intention to represent yourself in this matter, is that true?
It is my intention to present this cause.
Okay, you do not want me to ask the public defender's office to appoint you an attorney, is that right? You don't want that, right? And you do not want to retain an attorney, is that right?
Right, I'm competent and I will see these matters through myself.
All right, you understand, I know we've talked about this before, but you understand that Attorney Odette and the people that work in her office that are lawyers have law degrees, they've been through law school, they've been doing this for many years, and according to the people in the legal system, you are gonna place yourself at a significant advantage by representing yourself. Do you understand that?
Advantage? Yes.
A disadvantage. I'm sorry, I didn't say advantage, I meant disadvantage.
I see it another way, but that's.
And that's fine, that's why people represent themselves, they think that they can do it, and you seem pretty competent to me. As long as we all respect each other and respect this room, everything will be fine and you can represent yourself. I don't have a problem with that. But if we start crossing those lines, that's when we're gonna have a problem, okay? All right, I think that's it for today.
Thank you.
Thank you.
May I have a second for Mr. Renfro?